So we would normally leave time for a few stragglers to come in, but Bill Herbert has beaten into us that we need to have all the sessions start and end on time because the conference has such a rich array of offerings that we don't want anyone to miss things they want to go to. So this session, just to make sure you're in the right place, we do this with classes too, is Title IX, its past, its present, and its future. My name is Karen Stubis. I'm Vice President for Academic Affairs at Rutgers, and I am one of two moderators for this session. The other moderator is Sasha Modish at the end. There's Sasha from University of Michigan, and I'll give you Sasha's bona fides in a couple of minutes. We decided to do, when we were planning the conference, we knew that this would be the National Center's 50th anniversary, but the year before, last year, was Title IX's 50th anniversary, and we thought it would make a nice conjunction to talk about the 50th anniversaries together. As your conference program notes, we're intending for this to be a, quote, moderated conversation among a group of national experts, and you have the national experts at your panel, about Title IX, which, as you all know, is the U.S. federal civil rights legislation that was enacted in 1972 as a portion of the education amendments of that year. Title IX prohibits sex-based discrimination, including with regard to pregnancy, sexual orientation, and gender identity in any school or other educational entity receiving federal funding. Okay, my own experience with Title IX, just so you know the vantage point that I come to this subject from, is that I've been an academic administrator in faculty affairs at Rutgers University for some number of decades. And in that context, I've been very much involved in sexual harassment grievances and Title IX filings, primarily by graduate students and postdocs with regard to members of the faculty. So I'm not a Title IX coordinator, I'm not an attorney, but I come to it from the vantage point of what happens at the institution when some of these issues arise. In the earlier years of Title IX, soon after it was enacted, a lot of the conversation was about gender equity in terms of sports, and certainly our OGC's office spent a lot of time looking at how much money was being spent on women's athletics as opposed to men, and this was in my early years at Rutgers, and I remember being confused about why was there so much conversation about what kind of food was at the training tables, but that turned out to be a really important thing in terms of gender equity and so forth. And then over the years, more of the Title IX conversation, at least at my institution, institutions like mine, included the athletics emphasis, but also an emphasis on student-on-student sexual assault and also sexual harassment, sexual misconduct by faculty with regard primarily to graduate students. And so that's just to give you a little bit of background on how I come into this subject. As noted, we have a really wonderful panel of national experts who have been in the conversation about Title IX issues for lots of their careers, and I'm going to introduce them in the order in which they're sitting. If you sat in the right places, yes, everyone's sitting in the right place, good. And that will be the order in which they will speak. And then at the end of their presentations, Sasha will do a little bit of a wrap-up, and then we're going to open it up to you all for questions, and we hope to have a pretty spirited conversation. So don't hold back. We're here to learn from each other and to exchange our ideas. So first is Tammy Strickman. Tammy is Special Advisor to the President and Executive Director of the Office of Equity, Civil Rights, and Title IX at the University of Michigan. Tammy is going to start us off by talking about the creation of the current Office of Equity, Civil Rights, and Title IX at Michigan, including the why, the how, and the when the office was expanded and reorganized, what functions and services it currently includes, and how the dramatic expansion of the office is working out in terms of culture change, prevention or amelioration of sexual assault and sexual harassment on campus and other areas. I'm also hoping that Tammy will let us know of any bumps in the road in that process as it carried itself out in Michigan. given that it was a major structural change. We're very pleased to have Tammy on the panel because the Michigan office is often cited as a goal of many other Title IX restructurings that's happening across the U.S. and is currently under consideration at my institution. So Tammy, thank you. Next we have Lance Houston. Okay. Lance is Title IX Coordinator and Director of Equity and Compliance at Adelphi University. Lance writes and speaks on the interface of Title IX regs and higher ed collective bargaining, right in the sweet spot, particularly with regard to standard of proof. In 2020, Lance's research was cited in the Title IX Final Rule Regulations of the U.S. Department of Education Office for Civil Rights. This morning, Lance will be sharing with us his recent article, which is on the conference app. If you haven't downloaded the conference app yet, I encourage you to do so. There's lots of great stuff on it. And both Risa Leibowitz and Lance submitted some documents for you to look at for this session. So you can look at those after the session if you haven't looked at so far. Anyway, Lance's article is there, Title IX Law and Policy, Academic Labor Union Duty to Bargain Rights, and the Evidentiary Standard of Proof. And more specifically, Lance will be arguing that college and university labor unions at both public and private institutions may have both the statutory right under the NLRB for private institutions and similar rights under the various public sector statutes for the publics to collectively bargain the choice of evidentiary standard of proof, in other words, the preponderance of the evidence versus clear and convincing, in campus Title IX investigations, and that the standard of proof is in fact a term and condition of employment, which is very interesting take on where we are. So pleased to have Lance here as well. Next is Risa Leibowitz, my colleague as on the Board of Advisors of the National Center, and also Professor of Labor and Employment Law at Cornell University School of Industrial and Labor Relations, and also General Counsel of the AAUP on the national level. Risa will focus on Title IX and its interface with academic freedom and due process issues with regard to faculty, and we'll also be making a few observations about the upcoming, we hope, sometime in our lifetimes, new Title IX regs that are supposed to be dropping in May, and the areas in which the AUP National Office is hoping that some modifications have been made between the draft regs and the final regs. And the document that Risa had uploaded into your conference app is the AUP's comments on the proposed regs. Very, very interesting. So please take a look at those. Pleased also to have Risa here. And last but not least is my good colleague, Fraser Benya, Senior Program Officer at the National Academies of Sciences, Engineering, and Medicine in DC. From 2016 to 2018, Fraser served as a study director for the National Academy's consensus study report entitled Sexual Harassment of Women, Climate, Culture, and Consequences in Academic Sciences, Engineering, and Medicine. That's a report that from the National Academies that was published in June of 2018 on my birthday. I'll never forget that. And that really made the not very startling report that sexual harassment was still quite alive and well in academic institutions and in academic medicine. That report got a lot of national attention and sort of galvanized people who've been working in the fields of sexual harassment and Title IX for their whole careers in getting a lot of national attention and attention of our university leadership about the issue. And one of the outcomes of the 2018 National Academies report was the creation in 2019 of the National Academies Action Collaborative on Preventing Sexual Harassment in Higher Education, which Fraser directs, and which is, she'll describe the Action Collaborative to you in greater detail, but which has about 60 members right now. And it's actual taking of the 2018 report and putting it into action to create change and prevention strategies at our institutions. And it's been a real game changer, certainly for me and for a lot of my colleagues who are doing this work across the country. Finally, before we get started, I want to give you a little more about Sasha, who's at the end of the table. Sasha is Associate Vice President for Academic and Faculty Affairs and Senior Director of Academic Human Resources at the University of Michigan. Again, Sasha will do a little bit of wrap-up after the panelists talk, and then we'll open to questions. And I don't think I'm allowed to give you too much detail about this, but Sasha missed day one of the conference because she was locked up in a hotel room can I say? In negotiations. So, in some very hot negotiations. So we're very happy that Sasha was able to get release time to come over and join us today. Okay, just a couple of housekeeping pieces of business. Each panelist will speak for approximately 10 to 12 minutes. We're asking you to hold off on your questions until they're all done, and then we'll do a macro Q&A session at the end, towards the end of our time together. If when you ask a question you want to direct it to a specific panelist, please let us know that. But if it's up for grabs for anyone to take, let us know that as well. Okay, so thanks for your attention. Without further ado, we will start off with Tammy.
Well, good morning, good late morning, everybody. It's so great to be here, and I'm really excited to talk about not only Title IX, but a lot of the evolution of the office where I work at the University of Michigan. Over the couple of years I've been there, since 2020, we have worked to get a lot of feedback about our office in light of course, getting both community and campus input. And additionally, we had some matters that became rather high profile and of public interest within the last few years. And so working with the leadership at Michigan, it seemed like the time was really ripe to rethink how the office worked, who and what pieces of civil rights were part of the office, and how we could best serve our campus community. So I'm really going to focus on that today. We heard a number of different things, not only from campus community members, but also specifically from graduate students who were coming to the bargaining table and asking for certain things. And one of the overarching themes that we heard time and time again was a real emphasis on prevention and being proactive on the campus as opposed to reactive, which many times, especially as Title IX has evolved very rapidly, institutions are really scrambling to figure out how to best use their resources to address sexual misconduct. And usually that comes with investigation and response. And for those of you who have ever known somebody to go through an investigation, perhaps you are colleagues with people who do that work at your institutions or institutions you may work with, it's extremely draining and extremely difficult for everybody involved in those types of situations. And so we really wanted to think about how to reallocate and also get new resources to really beef up that prevention work that was so important to us. So as you see, and we're going to talk about it in a little bit more detail on the next slide, we really wanted to create more prevention and training within our office. I'm going to talk about equity specialists and how that's been a really successful addition and model to our office. Restorative justice that some of you might be familiar with, also sometimes called adaptable resolution, is another really helpful component. And we're really working with more collaboration across our campus. So with researchers, with practitioners, we actually have a summit coming up in May, and I'm happy to provide that information to anybody that may be interested in coming to attend. I think it's going to be a really excellent program to talk about how we can bring some of our work together collectively and collaboratively. And we also formed something called the CCRT, which some of you may be familiar with. It stands for Coordinated Community Response Team, and it's really an opportunity to bring together lots of different voices and perspectives to talk about issues around sexual misconduct. And at Michigan, our CCRT, which is comprised of about 65 people from across all of our campuses, so that includes Ann Arbor, Michigan Medicine, Flint, and Dearborn, we're broken up into subcommittees to work on specific priorities with regard to sexual misconduct, and each subcommittee will come up with a recommendation or some recommendations to provide to the president at the end of the calendar year. So I think that's another great addition that we've had. So I'm going to move quickly to the next slide, which talks about our new structure. So our office, when I arrived in 2020, was called the Office for Institutional Equity, OIE, a name that a lot of campuses use. And there were many great things about it. It was functioning well enough at that time. And one of the important things that we have maintained through our restructure is an office that combines all of the areas of civil rights, which I think is important, because oftentimes we do have situations with cross complaints or cross issues. And so it makes it difficult when somebody has to navigate which office to go to. You know, they're dealing with an ADA matter in one office and a Title IX matter in another office. So what we've done is we've combined and housed all of our different areas. So as you will see, oops, I'm going to try to use the pointer. Not well. Okay. So as you'll see here, we have our ADA director, our director for civil rights, so that would encompass the majority of our Title VII protected class issues, so race, national origin, religion, etc. Our sex and gender-based misconduct director, who's also our Title IX coordinator. And then I'm going to talk about sort of the bookends of this org chart in just a minute, because those are our new sections. But one of the things that's easier, I think, for our campus community is whether you're a student, staff, or faculty member, and you have an issue, whether it's sex and gender-based misconduct only, or, you know, it could be a race and a gender issue. Our office is the office that you come to make that complaint or to get additional information. And that stayed the same, and I think it's been a very beneficial model for our office and our campus. The two new things I want to highlight today when we sort of rebranded and moved from the OIE office name to Equity, Civil Rights, and Title IX, or ECRT, is first, we really wanted to highlight the need for that prevention education. So we have fully staffed this area, and we call it PAIR for short. Everything's an acronym at Michigan. And it's our work on prevention education, training, assistance, and resources. And so we do a lot of training, not only online trainings that we're working on for the whole campus, but oftentimes we have units or areas that are really looking for specific help on something. Perhaps it's a matter that's happened within the unit and they're looking for assistance on how to navigate it, and perhaps they just want their staff and their colleagues to be prepared for issues that may arise more proactively. So that's been a great new service that we've been able to provide to our campus, and housed within that is the restorative justice adaptable resolution piece I was talking about. We are lucky at Michigan to have a couple of national experts in this space, one named Carrie Landrum and another Karen Williamson, who is the director of PAIR. And I am happy to provide their names as well after the conference in an email, because a lot of people do contact them from other institutions just to find out how it works. And in a nutshell, they can present for days on restorative justice, but it's another way to address disputes and conflict resolution outside of an investigation. And so that's been another area that's been well received, where oftentimes Carrie, who's doing that primary work, can work with individuals within a unit that may be having issues. One of them believes that it's a gender-related issue, might not want an investigation, might not be appropriate for a full investigation, but certainly that we as an institution want to address adequately and appropriately. The other thing I want to point out is our Director for Intake and Support and our equity specialists, which I talked about in the last slide. So many institutions do hear oftentimes that hearing from an investigator, the person who's really going to be looking into a matter very closely and doing a lot of analytical work on a matter, is not the first point of contact that they want to hear from. So they rather hear about resources, they rather hear about different options that they have. So our equity specialists serve in that capacity, and it's been very well received. We started with 1, and we are now at 4 in about a year, maybe 10 months. And so what the role of the equity specialist is to make that first, what we call soft outreach. So if somebody has potentially been subjected to some form of sexual misconduct or other form of discrimination, the equity specialist will reach out and talk about all of the resources and reporting options so that individuals can make an informed decision for themselves on how they want to move forward. The equity specialist will then stay with both parties. They don't represent or advocate for either one, but they're impartial, and they'll support both parties and any witness throughout the process. So whether it's an investigation or restorative justice alternative, adaptable resolution, they will make sure that individuals feel supported and have the resources they need. Sometimes that looks like an academic modification. So for example, one of the parties may say, I'm really struggling, I have an exam coming up, could you help me work with my instructor to perhaps get an extension? Or, I'm looking to think about moving residence halls. Is this an option? What do I do? And so it alleviates some of that burden and stress off of the parties to have that equity specialist there to really help them. Other times it can be something like, I'm in the midst of an investigation and I'm really confused, I'm having a hard time, and I just want to sit down and talk through it a little bit more, and I don't want to talk to the investigator about it because the investigator's getting a lot of information, and so I'd rather talk to somebody that feels a little bit more comfortable. And so that's been a great model. I know other institutions across the country are starting to have similar positions. Some people call them intake coordinators, intake specialists, but it's essentially the same type of role. So I could go on and on about our office, but those are some of the significant changes that we've made that we so far are really seeing some success with. In terms of challenges, it is always difficult when you start something new. One of the biggest things that we are working on is messaging these changes to the campus community, because oftentimes people know the office from years past and they have a certain viewpoint on it, and they are concerned because these situations just are stressful and come with concern and angst at times. And so we're really working to get in with deans, with supervisors, with unions to talk about the changes that we have made. So with that, I'm going to turn it over to Lance.
Welcome, ladies and gentlemen. My name is Lance Houston. I'm the Title IX Coordinator and Director of Equity and Compliance for Adelphi University. And it's my honor to be here today. So I'll get right to the point. I believe that the future of Title IX is litigation. I believe that the future of Title IX in particular revolves around a couple of key issues. Number one, we know that from the proposed rules that, again, these are proposed rules, that the Title IX coordinator can serve as the investigator and decision maker. I think that invites litigation. As well, when it comes to the Title IX coordinator delivering to the respondent a summary of the evidence, I think that also invites litigation. But particular to this program today, I think the most important issue around litigation around Title IX involves collective bargaining. And so in particular, your right as a local campus union, your right to a duty to bargain, mandatory subjects of bargaining. And that's what we're going to talk about today in a very short, brief history. So I'll give you a very condensed legal history. I don't want to go into the full thing while we're here. I only have 10 minutes, and I think right now I'm down to 9, so I'll be kind of quick. But essentially, in NLRB versus Katz on 1962, we know that the Supreme Court said that you have a duty to meet, the employer has a duty to meet and confer in good faith with wages, hours, and other terms and conditions of employment. Another Supreme Court case, First National, 1981, the Supreme Court broke down in very particular terms the ways that we define work in our society. One of those ways was with work rules. Again, 1981, because they have a special relationship to the nature of the relationship to the employer. Thirdly, we know that from the NLRB and with precedent that those work rules I just spoke of include employee discipline, anti-discrimination policies, grievance procedures, and the like. Ladies and gentlemen, Title IX policy on your campus is a first national work rule. And that is the point of my presentation today. So what does that mean? What does that mean? So when it comes down to your right as a campus labor union or even administration to discuss or bring to the table the issue of this Title IX work rule, what is it? It means that when it comes to the decision around preponderance of the evidence or clear and convincing evidence on your campus, that is a choice to be made, a choice to be bargained, not for a unilateral decision around that issue. Now, we know that from my research, and you have I think you have access to the copy of that research included in the set. We know that from around the country, there are different universities that bargain this issue, from Harvard and Yale and Princeton to others who make no mention of it at all. But in my research, I found that with regard to the duty to bargain, the preponderance of the evidence standard versus clear and convincing, that most contracts do not speak to this issue. I'm talking public safety labor contracts, clerical union contracts, admin staff union contracts. Don't make an issue or don't at least address what that means for the campus. We know also, just going again, looking at the trends, with the proposed rules coming up in May, and we're hoping that it will in fact be May, the rules say that they're going to mandate preponderance of the evidence standard unless you meet certain criteria. That is, that your all other proceedings, including complaint procedures, are at the same standard. If they are, if they do in fact, are clear and convincing, then you have a right to, in fact, choose between clear and convincing and preponderance. That is a choice. That is a Title IX first national work rule. So we can see that from, again, you have access to the research, how important it is for labor unions, and especially important for these, the growing wave of graduate student unions forming on campus, those considering forming on campus, or maybe you're already established, and maybe you have sort of a very sort of simplified contract. Don't miss out on this important point. The point around, so again, if you're clerical, admin staff, groundskeeping, whatever it may be, it's so important to address this critical concern. And that's certainly, the foundation, of what I want to talk about. Is there a chance that it's not, I'll go back to my first point here. Okay, so going back to my research, what we also found is that there are in fact contracts that are very good, very well reasoned, that in fact have academic faculty, clerical staff and such, with a seat at the table with regard to the evidentiary standard of proof. So for example, Harvard University has a dedicated seat on its campus for labor unions to actually sit down and discuss and debate, negotiate what that standard will be. So I think, as we're here discussing how important, certainly collective bargaining is, I want to make it clear that with regard to Title IX in its future, that with regard to your choice as a campus labor union, that you don't miss this important point. What am I saying? I'm saying that we're talking about the issue of waiver, right? So if you have an issue at the bargaining table around your entire contract, but you don't actually address the standard of proof, you waive it. You waive that right for potentially many years to come. So we want to make sure that you have at least a chance to address that concern. Let's be clear. The rules going forward, again, the proposed rules under the Biden administration also make clear that when it comes to faculty, staff, and students, they will in fact allow different evidentiary standards moving forward. Again, a choice. So that's I keep saying the same word over and over again because it's so critically important that we pursue this evidentiary point. What I'll say in closing, ultimately, is that once the contract is negotiated and it's all set, it'll be important, I think, for the entire campus, ultimately, as one of my panel members said earlier, that restructuring, is a good thing. Of course, the rules are changing, and that's a good thing. But I think that the rules that they're written right now, I believe, invite litigation. I think they invite difficult questions for the campus, for each of your campuses coming up. One of those questions, again, will be around evidentiary standard. So I'm hoping with the research that I provided into the set, you have a chance to read through the research, understand the thinking behind it, and also provide education to your campus to make the best choice possible.
Thanks so much. It's a real pleasure to be here, and I'm going to steal a little time from myself here just to say that it's particularly meaningful for me to be at Hunter, and this relates to what we're talking about today because my mother was a student at Hunter High School and Hunter College back in the 1930s when it was all girls and then all young women together from working class families for free excellent public education, and what a difference that made for women who had those opportunities that I got to see up close and personal through my own mother and the influence that her education had on her for her entire life, and people who went to school around the same time as she did, like Bella Abzug. So this is particularly meaningful for me to be here at Hunter and to talk about these kinds of issues at this moment. So I'm here, particularly in my capacity as General Counsel of the AAUP, to talk with you about Title IX. And as I'm sure everybody here knows, and as we've mentioned here today already, that there will be the upcoming new regulations coming out of the Department of Education, probably in May, at least that's what they say this year. And AAUP submitted comments to the Department of Education about the proposed changes in the regulations that were put out last year, and in September we submitted our comments, our public comments, and they are available for you to read. And what I'd like to do is to talk about those comments and hit on some of the key points that we find particularly important at the AAUP, and that I hope will also be a good foundation for our discussion as well today. So first, one of the things that we point out in our comments is that we agree with some of the proposals. We welcome the fact that the proposed new regulations would cover all forms of sex discrimination in the regulations, not just have regulations addressed to sexual harassment. We also welcome the clarification in the new regs that Title IX's prohibition on discrimination applies to sex defined in terms of sexual orientation as well as gender identity. We also agree with the proposed expansion of the definition of sexual harassment, which is really way too narrow under the current rules, back to the severe or pervasive kind of standard. But at the same time, in those comments, we make recommendations from AAUP to amend some key points in the proposed Title IX regulations. And those have to do with our recommendations to emphasize the broad equity goals of higher education. Now, we don't address the K through 12 issues. Clearly, Title IX applies to K through 12 as well, but my comments and the AAUP's comments address higher ed, and in particular, we're addressing higher education with a focus on key issues for the faculty and other academic professionals, which includes all teaching and research faculty, librarians, graduate student employees, as well as staff, because Title IX affects all of them. We also emphasize the importance of thinking about job categories. If you think about faculty, the ways in which faculty at different in different status categories, whether it's tenure track, tenured, non-tenure track roles, that should make a difference in how we think about issues of gender equity. So I'm going to first now touch on the key points that we made in our comments, and then talk a bit more about all of them, but there's a lot to talk about, so I won't go into enormous detail on everything. First, we emphasize the importance to address gender equity within a more comprehensive assessment of bases for inequality, to broaden out our vision. Secondly, we address in our comments the need to protect freedom of speech, and in particular, academic freedom of faculty in their teaching and research. Third, we emphasize the need to protect due process adequately in investigations and hearings. And finally, this really relates very much to what Lance was talking about, we emphasize the importance of shared governance and collective bargaining to bring faculty expertise and institutional knowledge into developing and implementing policies related to Title IX. So I will address each of these in turn. Now, first, addressing this point about gender equity and gender inequity in a broader systemic context of inequality. The AUP, since we put out a big report in 2016 about these issues, have been emphasizing that Title IX should be viewed generally as through its goals of increasing gender equity and also in relation to racial equity and other forms of equity that are important to think about on campuses, and in particular with regard to the goals that higher education has. That Title IX is not a narrow sort of statute. It's not written in a narrow way, and it shouldn't be understood in a narrow way. Now, this kind of broader vision involves things like universities providing adequate resources and faculty and staffing for programs like gender studies programs, racial equity studies programs, racial justice programs, and allied programs in these areas. Without the kind of resources and support for these programs, the purposes of Title IX will simply not be fulfilled. Now, this is certainly closely related to issues of protecting faculty academic freedom to teach and students' academic freedom to learn. And these days, it's particularly resonant to think about Title IX in this way, given what's happening in Florida and other states with state government attacks on academic freedom and attacking programs like gender studies and like racial justice studies. And so we need to envision what Title IX can contribute to that broader view of protecting academic freedom in all of these kinds of programs. Now, we also have some specific recommendations with regard to academic freedom, in particular to make a more positive statement in the regulations about protecting academic freedom and due process, as opposed to simply stating that nothing should interfere or violate those provisions. We emphasize the need to recognize that speech through teaching and research and other kinds of public speech will oftentimes be contentious, will be controversial, and it will offend some students and other listeners, while at the same time, that kind of offensive speech is part of what's germane to teaching and what's germane to thinking about ideas in the context of higher education. And it's so important for us to recognize that Title IX should distinguish between unprotected conduct and unprotected speech, for example, sexual harassment, as opposed to protected speech. That is part of our teaching and research mission. And once again, at this moment, it's particularly resonant to be cognizant of these distinctions, given what's happened in places like Hamline University and the sort of attacks that faculty who teach in areas that may be considered controversial are being undermined by administrations simply jumping the gun. And in Hamline University, where the faculty member showed a painting in her art history class with regard to an image, which had an image of Muhammad, that she was attacked and accused of being Islamophobic by the administration because of a student complaint where the student found the image offensive. This is not sex discrimination or sexual harassment, but it relates to other kinds of statutes like Title VI with regard to race discrimination. You have to distinguish between protected speech and academic freedom as opposed to unprotected speech crossing a line into harassment. I also want to point out, and I think I have just a few minutes.
About 2 more minutes.
2 more minutes. Boy, it goes fast when you're the one talking. So I want to just touch on several points that perhaps we can have more discussion on in the Q&A and hearing your comments. And one of those relates to academic freedom in terms of the importance of our relationship with students, faculty and student relationships. The current regulations do not mandate or do not require universities to have mandatory reporters cover all faculty and all staff. Many universities do that, but it's not required under the current regulations. The proposed regulations would require basically all people who teach to be mandatory reporters, to report to the Title IX coordinator anytime that they hear something that may be sexual harassment or sex discrimination that students have experienced. And our position has long been from the AUP, and it continues to be, that this is an ill-advised and in fact destructive kind of mandate or requirement, because it really undermines our relationships with our students, and it undermines the students' trust in being able to come to talk to faculty, many of whom will be faculty who are women, people of color, that the students trust and wish to speak to. And so our position is that, in fact, the regs should be changed to prohibit those kinds of blanket requirements for being mandated reporters, and instead adopt policies like the University of Oregon has, which was developed through faculty governance, that has designated reporters who should be reporting when they have authority to correct a situation, as opposed to most faculty who would be in a position to assist students without having to report on them if the students wish to maintain confidentiality about their information. So in, I guess, my last minute?
Your last minute.
In my last minute, I will just touch very lightly on the due process piece, and then relate it as well to faculty governance and collective bargaining. The proposed regulations are very different from the current regulations. The current regulations have due process provisions that require a live hearing to be provided where there's a complaint, and either the complainant or the respondent wishes to have a live hearing to test the evidence, to hear the evidence. This is, of course, after an investigation, and to have a decision maker at that point, a panel, make a decision on a complaint. The new proposed regulations would not require a live hearing, and in fact would really water down the due process provisions in important ways. And so 2 key points that I'll identify is, one, the the current situation, the current regs, which provide that you cannot have a single investigator model where the investigator is also the decision maker, that prohibition should remain in place. The new regs would allow for the investigator to also make a decision, and we think that undermines reliability, and it can really enforce or reinforce even unintentional biases that may occur. And our position also is that in the interests of reliability and fairness for everybody involved, complainants, respondents, all people who may be involved, that the right to a live hearing, if either complainant or respondent asks for it, should be kept in place. And that for faculty governance and collective bargaining, that should be a very robust part of creating these policies, including the due process provisions. And thank you very much.
Thank you. Good afternoon, everyone. Oh, I'm too fast. There we go. Okay, so I'm going to talk a little bit about what it means to start going beyond complying with Title IX. The concept for this was actually relayed by Professor Anita Hill when she spoke with our National Academies Committee back in 2017. And in her remarks, she talked about treating Title IX as the floor, not the ceiling. We stand on the floor and we should be aiming a lot higher with what we do on this topic. So those comments were very impactful in the report and set the stage for at least one, if not other, of our recommendations. These are the 5 key findings from our report, and they serve to provide the research base for our recommendations. I'm going to draw your attention to just the last 2 of them. The fourth one being that the committee unfortunately found nothing to suggest that the anti-harassment policies and procedures that have been standard and part of compliance in this country have resulted in any significant reduction in sexual harassment. Additionally, they found that this was in part because the judicial interpretation of the law requires that these policies and procedures be in place, but not that they be effective. And so ultimately, the committee concluded that the legal system alone is not an adequate mechanism for reducing or preventing sexual harassment. Fortunately, there is research that shows that making changes to organizational cultures and climates can actually address and prevent sexual harassment. And the research on this is based around what factors predict high rates in sexual harassment. So there's 2 main factors. One is if an environment is male-dominated. There are a couple of different ways there. But the other one, the one I want to draw your attention to, is if the environment has a tolerance or conveys an organizational tolerance for sexual harassment. So this is that organizational climate piece. And the research shows that this climate can be created if the community perceives that reporting is risky, the community perceives that reports are not taken seriously, and the community perceives that offenders escape sanctions. Unfortunately, it is this organizational climate that is by far the greatest predictor of high rates of sexual harassment in environments. So building on that research and other research in the report, the committee made a series of recommendations for what institutions could do to actually address and prevent sexual harassment. These are the 6 overarching headings that make up the recommendations. There's a lot more detail in the report. It is 300 pages long, and it is available for free in case you would like to read it. But I'll just highlight for you because these headings are going to serve to map to some of the examples that I hope to show you in a couple minutes about what it looks like now to implement practices that go beyond just complying with the law. So the first recommendation is around addressing the most common form of sexual harassment, known as gender harassment. The second area was around creating diverse, inclusive, and respectful environments. This ties back to that male-dominated environment risk factor. The third is to diffuse hierarchical and dependent relationships between trainees and faculty, and this relates to research about how when there is a strong power differential, it can create more harm when harassment occurs. The fourth is to provide support for those targeted by sexual harassment. The fifth, to improve transparency and accountability. And the sixth, to strive for strong and diverse leadership on this topic. So as Karen noted, there was high attention and interest following the release of our report in 2018, and that led to our forming the Action Collaborative, which was designed to meet the needs of the higher education institutions who came to us and said, we want to do this work, but we don't want to do it alone on each of our campuses. We would rather build on the work that we're all doing in different ways. So we created this collaborative to bring together individuals who were working to develop, implement, evaluate, and share practices for addressing and preventing sexual harassment. A key part of the members' responsibility in being in this Action Collaborative is that they share every year publicly a description of work that they have done that aligns with the findings and recommendations from our report. And they do this so that they can benefit from their peer institutions, and also with the hope that they set some precedents within higher education that inspire the broader higher ed community to make these changes. Before I give you some of these examples of what this work looked like, I just want to highlight that all of the resources from the Action Collaborative are available for free on our website. We have a rubric that is used by our member organizations to identify relevant work to share. It is a list of the topic areas that align with our findings and recommendations, and so that may be useful to other institutions as well as they identify where they could be doing work. We do produce an annual report that summarizes each year the work the members have done, but most importantly, we created an online repository of work that is a collection of these 2 to 5 page descriptions of the work the members have done. I'll just highlight, we created it to be filterable by both topic and institution name so that you can get to what it is that you're most interested in. And as I describe some of the example practices here in a moment, I'm going to reference the institution name, and so you can use that to look them up later. Okay, so what does it look like? And I'll just start by saying almost all of these practices did not exist in 2018 when we released this report. So this is what has happened in the last 4 years. We've seen multiple institutions do work to create mechanisms and practices, policies around checking references for applicants to their jobs, particularly around checking their past behavior, mostly around actual findings from investigations. Most of these institutions rely on a system that was developed sort of simultaneously by the University of California, Davis, and the University of Wisconsin system, which creates a waiver that the job applicant signs, which gives the hiring institution the right to ask the applicant's current and past institutions about whether there are findings of responsibility in their past. There are also policies, moving on to the second example, to close what you might call loopholes in institutional systems that prevented committees for reappointment, promotion, awards, and tenure from being able to know whether or not someone had been found responsible for sexual harassment. And Karen has led most of this work, is my understanding, at Rutgers, so I'm sure if you have questions about that, she would be a great person to talk to. There have been also efforts to increase transparency around the range of disciplinary actions and how those decisions are made. This example from the University of Minnesota relates to a document that they produce that lays out the principles by which disciplinary actions are mapped to the severity of the behavior, how they maintain some consistency across institutions, and mainly was set up to address the concern among the community that they didn't have any information about how these disciplinary actions were taken and whether, the discipline in this case was on par with the discipline in another case. So there was a lot of lack of trust in the system, and this was an effort to kind of build that trust and be more transparent about what is used. There's also been efforts around anonymous disclosure and reporting systems, and also the use of ombuds offices, which help survivors to timestamp and take notes on their experience without the pressure of needing to proceed into a formal investigation right away. Efforts around creating customizable anti-retaliation plans, and I would actually describe this as really an effort around preventing retaliation, whereas a lot of institutions want to just tell everyone, don't retaliate, it's illegal, and then wait to see what happens. This is actually an effort in which survivors come to them and say, this is the type of retaliation I'm most afraid of, and the institution develops a plan to try to insulate them from that. There's also, I know we spoke a little bit at the beginning about restorative justice. This is kind of a slightly different take on restorative justice practices. This is an effort to try to restore the what might have been had that student not been disrupted by sexual harassment. So in this case, the University of Washington Title IX officer and one of the survivors from an instance several years back came together, and this survivor was a graduate student. She was partway through writing her dissertation when the harassment occurred, and she ended up having to leave the institution because she didn't feel she could continue. But they came back together years later. This was a new Title IX officer who was not around when the first harassment was experienced, and they proceeded with a process of allowing her to finish her dissertation. They formed a new committee, worked with that committee, and gave her the chance to defend, which she successfully did. So that's just, well beyond what is required by the law. The last two examples here are one about reducing power differentials, and I'll just note that when we first started talking about this in 2018, most institutions, people on campus would go, oh, that's a problem for the federal funders of research. It's all about that PI and grant status, and we can't do much about it. But I want to highlight both of these examples because both MIT and Vanderbilt did not let that stop them. They looked inside their internal systems and asked the question of what about their systems was reinforcing this strong power differential. So MIT has created now an institution-wide, it started at the department level, source of independent funding to allow students to transition from one advisor to another. Basically means that they get one semester of funding if they need to leave their advisor. They do not have to file a formal report or go in through an investigation in order to access these funds. In the case of Vanderbilt, they looked at a program that they had in one of their science departments where students were being directly admitted by one faculty member to work with them. So there was no committee within the department that was reviewing things. It meant the students felt more isolated. They were not going through orientation with all the other graduate students. And so they redesigned that program to give the students a bit more access into a peer network and to have additional faculty members that would work with them. And then lastly, this example from the University of California, Santa Cruz is one in which they created a proactive plan based on the various scenarios that could play out after a graduate student experiences harassment. For instance, who's going to write their letters of recommendation? What's going to happen if they need to drop a class, but they have a visa status, and now that's in jeopardy? So they ran through all these scenarios, identified potential solutions, and identified positions within the institution that would become responsible for this. A very proactive approach that also was transparent in that it gave the graduate students that information up front so they could know what resources would be available to them. So I'm going to stop there. There's plenty of other work within the Action Collaborative, but I tried to focus on the ones that look very much like going beyond Title IX compliance.
Well, thank you all very much. This is an incredible panel you have here today. So this is your opportunity to ask any questions you have, and we have some questions ready just in case, but we knowing this group of folks as we do, we suspect some of you may have some questions for our group. So please feel free. I think we have the microphone set up for, and it's hard to see you up here. We have the microphones. We do have the microphones set up. So if you raise your hand, I think someone will bring you a microphone? I'm looking to the back. Yes, someone will bring you a microphone if you raise your hand and want to speak. And while you're all contemplating that, let me start with some of our questions that we have for this group. So, as we've discussed today, Title IX has evolved over the years. You've heard today the impacts with Title IX as it relates to shared governance, to collective bargaining. I think you heard also from I think every single one of you talked a lot about the need for the culture to change, to really to manage accountability, to move us to that next step. So we've made a lot of progress over the past many years. So what challenges, panel, have the changes presented to universities and or to the collective bargaining process? And any one of you can jump in, or I'm gonna call on you. So one of you should jump in.
Well, I'll jump in.
Thank you, Lisa.
All right. Well, I think that one of the challenges in regard to collective bargaining, shared governance, relates to the way in which universities themselves have changed over time under this kind of corporatized structure that we're living in right now, with universities being far more hierarchical, top-down, as opposed to more democratic in the way that shared governance has worked when it's worked very well. That's reflected in the ways in which Title IX is being put into effect as well. So that one of the things that is really important, and AUP's position is clear on this as well, is that rather than a Title IX office being viewed as or created as a very separate kind of office on campus where you have non-faculty members, non-faculty staff who are part of that office carrying out the work, separate from faculty, that governance, shared governance, and that includes faculty senates and other kinds of shared governance, as well as collective bargaining, which is part of that kind of shared governance vision that can coexist and does coexist with things like faculty senates, that the faculty expertise and the faculty rights to engage in governance should be made part of this entire process of creating policies, implementing policies, deciding through negotiations with the administration, whether it's shared governance or collective bargaining, about what the due process provisions should be like, and to really envision Title IX as part of that whole governance process rather than separate. And I want to emphasize that what I've heard from my colleagues here, which I want to repeat, is that Title IX is a floor, not a ceiling. And so even if the regs are changed in ways, for example, that I think an AUP views as not appropriately robust with regard to due process, it's through governance and collective bargaining, as Lance is pointing out, that can also be strengthened.
Anyone else from the panel?
I would say one of the challenges, or I would reframe it as revelations coming out of, I think, our 2018 report, was around the power of this concept of organizational climate. We like to think that if we put out rules and we say what is going to be done, how things are going to be handled, then that will convey to the community that is the belief and that's how things will work. That is actually the organizational culture, those like very official statements and policies. The organizational climate is how people live and experience the environment on a day-to-day basis. So it's more about how does the community perceive what's going on, how do they experience it, what sort of conversations are happening at different groups and levels. And there has been an overly compliance-based approach for decades on this topic, and that has led to a very, by-the-book kind of approach. This shift to organizational climate has opened the door to not just Title IX officers and general counsels being held responsible for handling this issue, but department chairs, deans, university presidents and provosts. that it is part of their realm of responsibility in creating this climate where harassment is discouraged. And it's one of the key pieces of the Action Collaborative that makes our space rather unique, is that we bring together a whole range of different positions within a higher education institution to talk about this issue. So we have working groups, Karen is in one of them, and it includes general counsels, people in Karen's position, department chairs, and sometimes prevention specialists. So it's all across the board, and I think that's one of the challenges has been we've been too siloed on this topic.
Thank you.
I would agree with that. I think one of the challenges is that this is primarily compliance driven, and so there are a lot of rules and parameters that we have to follow, and it can be at times difficult to get around them. Sasha and I live in the 6th Circuit, and so cross-examination is here to stay. So whether or not the regulations change or the proposed regs change in May and then become final rule, getting rid of hearings, at least on student cases, we need to follow that model, and we have in the past taken the position that we're going to treat faculty and staff through the same processes as much as we can so we don't have these large discrepancies. So we really are working to get voices and perspectives from, as I said earlier, faculty, researchers, people that do the work in the academic space as well as the day-to-day grind in the ECRT office. And that's where I think a model like the CCRT can be really helpful, because it does give the opportunity to have those discussions. And also when there are things or ideas that people have that don't know the kind of restrictions and laws governing these processes, we can have that dialogue and I think a great conversation to hopefully have some compromise and meet in the middle somewhere.
Thank you, Tammy. Before we have a question right down there at in the beginning.
Thanks. I actually have two questions. The first one is sort of micro, and I'd like to direct it to Tammy and Risa in particular, and has to do with due process.
Could you, when you actually ask your question, I'm sorry to interrupt, just identify yourself and where you're from.
Sure. Carl Levine. I'm a labor-side labor attorney representing faculty unions. So without naming institutions and obviously not individuals, I recently had cause to advise a union going through representing a faculty member in a due process hearing, and the institution hired an outside expert to run the hearing. And in the hearing, the advocate for the union was told to submit their questions ahead of time. 3/4 of the questions they wanted to ask were rejected. They had nothing to do with prohibited subjects like background. And in addition, they were asked to do things like submit their quote-unquote closing statement before the hearing began. And the hearing officer, the outsider, indicated before the hearing began that they would remove themselves after the hearing and come back a few minutes later with their ruling, all of which caused serious doubts in our mind about whether that was adequate process. So my first question for the two of you who I think are most involved in actually running or advocating in connection with due process hearings is what you consider to be adequate due process in these hearings. And I guess somewhat related to that, I'd like to know from Lance, I appreciated very much your presentation. I'd be curious to know whether you have any personal views as to whether the preponderance or the, slipping my mind now, I should know, but the higher standard, the clear and convincing evidence, is the more appropriate standard.
So without knowing the specifics of the hearing and all of the conversations in context, under our policy, we do have more of an opportunity for what I'll describe as a live hearing and having questions asked there kind of in the moment with not as much pre-preparation as what you seem to be describing. In addition, for the most part, our hearing officers do take some time to come back and render a decision. So I am not aware of a hearing that we've had so far where they have been able to come back with a full decision if both parties are participating. So of course, we do sometimes have hearings where a party doesn't show up, or a party shows up and decides they don't want to go through with a full hearing, where we still might have some contextual information that the hearing officer is going to hear and preside over. Those, of course, would be much more expeditious in terms of an outcome. So it's hard to comment on a specific hearing. I think in terms of adequate due process, we certainly want somebody who is going to be impartial, listening carefully to all of the evidence that's been presented by both parties, and to really take appropriate time, whatever that is for that particular external decision maker, to come back with a thoughtful decision. And certainly they should give both parties the opportunity to present relevant evidence, and that's where it can sometimes get tricky, because what one party might deem to be relevant, the hearing officer might make a decision based on, other information that goes a different direction. But so long as they're providing both parties adequate opportunity after giving them notice of the specific claims to present information, that I think would fulfill the process requirement.
Yeah, great, thanks. I'll just point out some sort of elements of due process that are important. The first is fairness, and the second is reliability. So those are, that creates at least a framework to think about what would adequate due process look like. It needs to serve interests of fairness and interests of reliability, and everybody should be interested in that, whether they're complainants, respondents, the institution, whoever's involved. As I said earlier, there are certain things that AEP's taken position on as not fulfilling due process, like the single investigator model, where you have the investigator and decision maker being the same person, which would be allowed under the new regs, is not currently permitted. And in general, what we're looking at as adequate due process and what AEP's position is everybody has an interest in having written notice of allegations, the right to the presence and participation of an advisor, the opportunity to review evidence and to present evidence, and to do that at a hearing if one party wishes to have it. It doesn't mean you have to have a hearing if the parties don't want to have one. And then also a written decision about whether the alleged misconduct has occurred, as well as a process for determining discipline. AEP's position is that the clear and convincing evidence is the appropriate standard because of the stakes that are in play there. This can be life-altering for a respondent who's charged, and that's true whether it's a student or a faculty or a staff member. This can be life-altering, whether it's a suspension, an expulsion for students, suspension or discharge for faculty or staff. These are huge stakes, and so we want to be able to have fair, reliable proceedings that present the evidence and test them in ways that we can rely on. And I can say more later if there's another question about that in terms of issues of bias, but I think I'll leave it at that. Oh, and then just to say, this is also the floor, not a ceiling piece, where governance and collective bargaining is essential to think about what will work in that particular campus, looking at different models of fairness and reliability, but fashioning it through the entire community coming together around it.
Sure. So to answer your question, I do not have an opinion, a personal view on what standard should be each school should choose for for its campus. I have no opinion on that, but I do have a huge opinion on how we arrive at that decision. I think a lot of times we, as I mentioned in my presentation, we leave out the clerical unions, we leave out the public safety unions, the groundskeeping unions, and we, and certainly, all the unions have a voice and a choice This is critically important, but I believe that that is important for all members of the campus community, not just one particular group. But I want to say one important point. While I don't have a view of what the standard should be, I want to kind of remind everybody that pre-2020, back in the DCL 2011 days, we had universities that had a 0% responsibility finding through the investigations. We had universities that had a 100% responsibility findings and investigations. How is that possible? Not what's possible, no investigation, no standard. So yes, there needs to be a standard. Yes, there needs to be one that's arrived at collectively between the unions and the administration, but I do not have a view of what that standard should be.
I think we have another question.
Melissa Sortman, Director of Faculty Academic Staff Affairs at Michigan State. I would like, Fraser, this is a softball, but can you let people know how to get involved? Because I think if we do not deal with the water we are swimming in, we are never going to deal with the violations and the compliance and everything else. And so the key work that Karen's doing, Fraser's doing with the Action Collaborative is the practitioner part of changing the environment that we are all working and educating in, and all of those pieces. And Michigan State obviously has had its tragedies and crimes, and so we shouldn't all wait till that happens, because that's, quitting smoking after you've been diagnosed with cancer isn't exactly the way to start. But that piece of the momentum to change is the key to actually making the compliance piece less of an issue, because we've dealt with the water that everybody is swimming in these higher ed institutions, which are some of the last bastions of saying you can't act like that here, or we don't allow that behavior here. And I think the important work of the Action Collaborative, Fraser, of how people can get involved and use those resources, because it is where the practitioner piece comes into play. And maybe, Tammy, what you're doing at U of M too on the prevention piece, but we sound like prevention means we're going to stop something versus the change of which you're going to make about what the working environment is. And it involves the unions and it involves academic governance. And I will say the leaders of both at Michigan State have been partners in making those things better, so that we're not dealing with only the compliance. Thank you.
Thank you, Melissa. To get involved, each year the Action Collaborative accepts applications for new members to join in the December-January time period. There have been some years when we have not had applications. That's just been because we've been at max capacity. And we keep the Action Collaborative constrained in order to facilitate collaboration well across the institutions. We do also have a partner network, which allows institutions to share some work they're doing on an annual basis, but without the time and financial resources that are involved with being a member. So that just means they are sharing and are wanting to be aware of the work the Action Collaborative members are doing, but it doesn't come with the same sort of bandwidth and financial and time resources.
Tammy, did you want to comment?
On the prevention
Yeah.
work? Sure. I think the reality is we'll never prevent sexual misconduct, unfortunately. But some of the things that we are working on with our prevention education is really empowering colleagues to speak up when they see something that they're not comfortable with. Getting unit leaders more involved, as the point was made earlier. We're seeing now more chairs, deans, others being held accountable, and we should hold ourselves accountable to call out behavior that doesn't align with our culture and what we believe is appropriate conduct. And the other thing that we're doing as well is working proactively with the units that know that they have an investigation or a situation that is ongoing. So now with social media, people find things out sometimes before our office even finds out what's happening. And so in the past, I think it was much more common for Title IX offices to get contacted after something kind of exploded, to say, now we don't know what to do. Everybody's talking about it, they're involved. So what can we do on the front end to get groups together that have some type of interest or stake in what might happen to address it appropriately, to what I'll say, quote, prevent it from getting worse. to the extent that we can. And so I know, for example, Sasha's unit, mine, OGC, sometimes deans, chairs, we get together to talk about these issues as quickly as we possibly can, just so that we are more prepared, and I think it helps the overall culture and climate at the institution.
Any other, right there?
Yeah, hi, Aaron Nissenson, AAUP, and sort of more like not an AAUP question, but a personal one, which is, I totally understand the fact that, and I think it somewhat the opposite in that they tend to provide a solution that's boxed up, and then people don't look at the climate. One thing I'd be curious if any of you have experience with involving unions in trying to figure out how to address the climate, you know, putting aside the Title IX reg part, and also why we have all these unions here, you know, maybe think about involving them more in these sort of climate affirmative solutions rather than just the sort of legalistic, how the process works issues.
I don't know how many of our practices actually involve the unions in those things. But I can share with the MIT and the transitional funding that the impetus for taking what was a departmental policy and making it an institutional one came out of the work of a group of graduate students on campus. I don't know whether they were acting in a graduate student union format. I don't believe so, but that is the kind of work that has been done through the Action Collaborative, where groups have advocated to their institution that this is the key piece that they feel is going to help change the climate where they are. And I would say plenty of these examples are things that could be advocated for at an institution. I'm not an expert in collective bargaining, so I can't say for sure, but these are all things that could provide additional resources to individuals who may actually be the survivor and be part of a union.
I think we have time for...
Oh, can I just jump in a
Oh,
little
sure.
bit on
Yes,
Aaron's
go ahead.
question? You know, I think that that question goes back to for me, the first point that I made and that AUP continues to make, which is to envision this as a broader equity issue about the goals of moving towards equity on campuses, gender equity, racial equity, the ways in which we know inequalities work, the way that the university is structured. And so most lawyers, I think, understand, as Aaron's expressing, as I'm expressing, and others are expressing, is that looking at this as a narrow legal question is not going to do it, right? I mean, that's not going to move towards those goals. And also looking at only sexual harassment is too narrow a vision of what Title IX is supposed to encourage us to do. And that's why I think it's the emphasis in not only collective bargaining, but also shared governance to say, how do we have a more democratic process where people come together and talk about these issues broadly? The climate issues, the cultural issues, but also what are we doing as an institution, if whatever campus one is in, to support the programs, academic programs and other programs that are addressing issues of inequity and inequalities. And so on the one hand, for a university to say, well, we care a lot about Title IX, but then they don't support gender studies and racial studies, or if it's a public campus, they give into a state government saying, well, you know, we want you to cut back on your racial studies programs. You know, that is completely inconsistent with saying that you believe in the purposes of Title IX.
I think we have time for one last question.
Hi, my name is Ellie Ballinger. I'm a student at Hunter College studying women's and gender studies. My question is mainly directed at Tammy, because you spoke about the growth of the ECRT and like the PAIR program, but it seems like a lot of the growth in education and support programs are directed at like the post situational solutions, like how to report, how to deal with gender-based discrimination once it's already been done, but what is being done to prevent it, like at its source, like educating young men on how to not assault women, or like dangerous circumstances that they should be aware of in order to make that not happen in the first place, and educating professors on how to not discriminate based on gender before it's already been done.
So in terms of a lot of the prevention efforts surrounding students, the University of Michigan has a long-standing office called the Sexual Assault Prevention and Awareness Center. And that office lives within student life, where a lot of that programming takes place and has been very successful. I think that started in the 80s, Sasha, around that time. And so Karen Williamson, who's the director of PAIR and ECRT, was actually the director of SAPAC for a long time. And she found that there were gaps on what you just talked about, kind of with the instructors and training more on prevention efforts and values and things that kind of fall in that bucket with our faculty and staff. And so PAIR and SAPAC work very closely with one another to cover that whole range of training, and they do still do a lot of collaborative training as well. In addition, we also have something at the university right now that's called our Culture Journey, and that's being led by the head of our organizational learning unit. And that is really identifying values and being really proactive and sort of prevention focused on what we want our values to be, so that we don't have situations where there is rampant sexual harassment. You know, that we are working collectively as a community to address it from all of these different angles. So while PAIR doesn't do it in isolation, it's working with the Culture Journey, with unit leaders, you know, with SAPAC to cover as much ground as we can.
And I think Tammy also mentioned some of the training that PAIR and others have done for individual units who request it, as well as individual units who come in and say, we may not have a case right now, an investigation happening, but we recognize that our climate, that we need help with our climate. And so some of the members of PAIR have come in to really help facilitate those conversations to get it to, you know, before you get to something that is an investigation and terrible, that we can have those conversations in advance, and that's important work that's occurring and that needs to occur. I think also I will just a plug, accountability and transparency is important, and it's certainly beginning slowly but surely making a change at our institution at the University of Michigan. Holding all of us accountable, I think, is very important. So I'd like to, before I release all of you and the panel, just say, if you want more of this, a little plug for a panel for tomorrow at 11 a.m. in the Roosevelt House. It's non-discrimination contract clauses, substance and procedures. So that's Tuesday, March 28th at 11 a.m. at the Roosevelt House. Panelists, thank you very much. All of you, thank you for coming. Enjoy the rest of the conference.